In this case, there was no evidence whatsoever that the procedural requirements of Esther were complied with by Ms. Deache in evicting Mr. Snyders. Indeed, as I've indicated, there was no evidence that the right of residence of Mr. Snyders had been terminated. To the extent that Ms. Deache and the Magistrates Court relied on misconduct or a breach of the provisions relating to residence, the majority judgment points out that Esther required Ms. Deache to give Mr. Snyders an opportunity to remedy such breach, and such breach had to be material. On the record before the court, I find that there is no evidence that Ms. Deache afforded Mr. Snyders any opportunity to remedy any breach as contemplated in Esther. In the result, the conclusion reached by the majority judgment is that the Magistrates Court was wrong to conclude that Ms. Deache had complied with Esther and that an eviction order should be granted against Mr. Snyders and his family. The result is that the appeal by Mr. Snyders should be upheld, and that the order of the Land Claims Court, as well as that of the Magistrates Court, should be set aside. Then the next question that the majority judgment deals with is whether or not this court should grant an eviction order against Mr. Breda and his family. It concludes that it is just and equitable that an eviction order be granted against Mr. Breda and his family, but the majority judgment points out that the eviction order is not an eviction order against Mr. Breda from the Stassen farm. It's an eviction order relating to the house which he presently occupies, which was previously occupied by Mr. Snyders with his family. In this regard, the majority judgment points out that as in October 2015 and November 2015, there was, according to the affidavits of both Ms. Deache and certainly Ms. Deache, a Wendy house available, which she said Mr. Snyders and his family could occupy. She described the Wendy house as providing proper accommodation. And the majority judgment points out that if the Wendy House provided proper accommodation for Mr. Snyder's and his family, it would mean that Ms. Deache could make that Wendy House available to Mr. Breda and his family in order to ensure that Mr. Snyder's and his family are able to move back into the house from which they were occupied. The majority judgment includes an eviction order, therefore, against Mr. Breda and his family, but gives them 14 days from the date of the handing down of the judgment within which to vacate the house, failing which the sheriff is then authorized and ordered to evict them. That means that they do have some time to remain in the house before they vacate the house. Froneman J. agrees in a separate judgment, which is the joinder judgment to which I referred earlier, agrees with the majority judgment on appeal, except in regard to the issue whether or not Mr. Breda should be joined, and except in regard to the eviction order. He takes the view that no eviction order is necessary. In the result, the order of this court reads as follows. 1, leave to appeal is granted. 2, the appeal is upheld. 3, the orders of the Land Claims Court, the Supreme Court of Appeal, and the Magistrates Court for the District of Ladysmith are set aside, and that of the Magistrates Court is replaced with the following, open quotes, A, the application is dismissed with costs, close quotes. 4, Mr. Willem Breda, his partner or common law wife and children are ordered to vacate the dwelling or house which was occupied by Mr. Carl Snyders and his family before 1 October 2015 within 14 calendar days from the date of this judgment. 5, should Mr. Willem Breda and his family still be in occupation of the house or dwelling referred to in 4 above after the expiry of the period, the sheriff is authorized and ordered to immediately evict him and his family or anyone occupying the house through him from the dwelling or house previously occupied by Mr. Carl Snyders and his family on the farm owned by Mr. F.L. Stassen. 6, the orders in 4 and 5 do not authorize or order the eviction of Mr. Willem Breda and his family from the farm owned by Mr. F.L. Stassen and managed by Ms. Louisa Deache. 7, Ms. Louisa Deache must pay the costs of the application for leave to appeal and the appeal in this court, the Supreme Court of Appeal, as well as the costs of the proceedings in the Land Claims Court. That is the order in the main judgment. I am now going to read the orders in the three other judgments. Well, in regard to the interim relief judgment, I am actually not going to read any order, because that judgment is simply the provision of reasons by this court for the order that it made in October last year already. So I am going to read orders in the two other judgments, that is the one for contempt of court and the one for joinder. And I start with the one for joinder, and that order reads as follows. One, Mr. Willem Breda and his family are joined as the second and further respondents in the application for leave to appeal brought by the current applicants in the proceedings under case number CCT 186/15. Two, there is no order as to costs. The order in the contempt of court application reads as follows. In the result, the application is dismissed with no order as to costs. I hand down all of these judgments.